What's up, guys? Assault Weapon Bro checking in, and today we're going to be talking about how a federal judge in California has struck down the California assault weapons ban. So on June 4th, federal judge Roger Benitez issued the ruling in the case formerly known as Miller v. Becerra, currently known as Miller v. Bonta, and he struck down the over 30-year-long assault weapons ban in the state of California. Now, as you can probably imagine, reactions to this from the politicians in California, especially those who have historically supported this legislation and continue to strengthen it as the years have gone on, they were not too happy about this. As you can see here, the response from Gavin Newsom. You can see here he issued a statement where he says, quote, "Today's decision is a direct threat to public safety and the lives of innocent Californians, period. As the son of a judge, I grew up with deep respect for the judicial process and the importance of a judge's ability to make impartial, fact-based rulings. But the fact that this judge compared the AR-15, a weapon of war that's used on the battlefield, to a Swiss Army knife completely undermines the credibility of this decision and is a slap in the face to the families who've lost loved ones to this weapon. We're not backing down from this fight and will continue pushing for common sense gun laws that will save lives." Also, the Attorney General who was named in the lawsuit, Rob Bonta, decided to respond here. He says, "Today's decision is fundamentally flawed and we will be appealing it. There is no sound basis in law, fact, or common sense for equating assault rifles with Swiss Army knives, especially on Gun Violence Awareness Day and after the recent shootings in our own California communities. We need to take action to end gun violence now. We will fight this ruling and continue to advocate for and defend common sense gun laws that will save lives." So yes, Judge Benitez did issue this ruling on Gun Violence Awareness Day. Probably a coincidence, but still also kind of hilarious. And you also see this Swiss Army knife comparison to an AR-15 quote in both of the statements by the governor and the attorney general. So let's take a look at some of the excerpts from this decision that Judge Benitez put out. So right away here in the introduction, we can see right at the beginning this Swiss Army knife AR-15 comparison where he says, "Like the Swiss Army knife, the popular AR-15 rifle is a perfect combination of home defense weapon and homeland defense equipment. Good for both home and battle, the AR-15 is the kind of versatile gun that lies at the intersection of the kinds of firearms protected under District of Columbia v. Heller and United States v. Miller. Yet the state of California makes it a crime to have an AR-15 type rifle. Therefore, this court declares the California statutes to be unconstitutional." So I understand what he means when he says the AR-15 is like the Swiss Army knife. Usually when gun rights advocates make this sort of comparison, they're talking about how versatile the AR-15 is. And to be fair, in this decision, pretty close to when he says this, he uses the word versatile. But the way he kind of constructed this sentence talking about how, like the Swiss Army knife, the popular AR-15 is a perfect combination of home defense weapon and homeland defense equipment. Obviously, the Swiss Army knife is not the perfect combination of home defense weapon and homeland defense equipment. So a little wonky on the wording there, but I understand what he means when he compares it to a Swiss Army knife. So everyone's going off about this Swiss Army knife comparison. But if you actually understand why people make the comparison, it actually makes a lot of sense. Swiss Army knife, very versatile, can be used in many different ways, can be accessorized and all these kinds of things, much like an AR-15, where you can put an attachment here, put an attachment there, different caliber sizes. There's all kinds of ways you can modify and utilize an AR-15, whether it's for home defense, whether it's for homeland defense, whether it's for sporting, whether it's, competition shooting or hunting, all these different types of applications. Now, you see in the beginning of this decision, he mentioned the Heller case. Now, the Heller case is the 2008 gun rights case that was written by Antonin Scalia of the Supreme Court. And this held that the Second Amendment pertains to an individual right to keep and bear arms. And in this decision, they talked about this idea of common use, that guns or weapons in common use would be protected. Not necessarily 100% of the time, but generally this is like part of the rubric you would use to analyze whether a gun is protected under the Second Amendment. So this common use test is something that comes up. And what was mentioned in this decision, a particular part that I like, is where he compares the popularity of the AR-15 rifle to that of the most popular truck in America, the Ford F-150. Because it would be hard to say that something is not in common use when there's literally more of that weapon than there are pickup trucks, the F-150 trucks in America. As you can see here on page 15 of the decision, more popular than the Ford F-150 pickup truck. Modern rifles are popular. Modern rifles are legal to build, buy, and own under federal law and the laws of 45 states. There are probably more modern rifles in circulation than there are Ford F-150 pickup trucks. In 2018, 909,330 Ford F-150s were sold. Twice as many modern rifles were sold the same year. Imagine every time one passes a new Ford pickup truck, it is a reminder that 2 new modern rifles have been purchased. That is a lot of modern rifles owned by Americans. Other courts agree. Quote, even accepting the most conservative estimates cited by the parties by amici, the assault weapons at issue are, quote, in common use, as that term was used in Heller. The judge also goes off on media promoting these mass shootings. As we can see here on page 90, perhaps there are better experiments that can be tried by the state to reduce mass shootings. As stated previously, shooters seek notoriety in news coverage. Perhaps restraint in news coverage might be a novel approach. Perhaps the better education of our children, or perhaps the expansion of our mental health care system, will be the answer. In the end, the Bill of Rights is not a list of suggestions or guidelines for social balancing. The Bill of Rights prevents the tyranny of the majority from taking away the rights of a minority. When a state nibbles on constitutional rights, who protects the minorities? The federal courts. The Second Amendment protects any law-abiding citizen's right to choose to be armed to defend himself, his family, and his home. At the same time, the Second Amendment protects a citizen's right to keep and bear arms to use should the militia be needed to fight against invaders, terrorists, and tyrants. The Second Amendment is about America's freedom, the freedom to protect oneself, family, home, and homeland. California's assault weapon ban disrespects that freedom. And in saying that, it appears that Judge Benitez, also known as Saint Benitez, because this is not his first rodeo, he was also the judge who was kind enough to give us the ban on the ban of high-capacity magazines, or what many would call standard capacity magazines or whatever. But it gave Californians this Freedom Week where they could buy a bunch of these and not face the consequences. But this judge really understands what the Second Amendment's about. It's not about hunting. It's not about sports or recreational shooting, or at least not only. And it's certainly not only about self-defense either. It's also about protection of the homeland, protecting against tyranny and things like that. And this judge is one of the very few to actually put that in writing in a decision of his. And the last portion I'll read from this decision on page 92 here. As Heller explains, the Second Amendment takes certain policy choices and removes them beyond the realm of permissible state action. California may certainly conceive of a policy that a modern rifle is dangerous in the hands of a criminal, and that therefore it is good public policy to keep modern rifles out of the hands of every citizen. The Second Amendment stands as a shield from government imposition of that policy. And I think that's just beautifully stated. Just because there is a noble goal in mind where, okay, having guns in the hands of criminals is bad, therefore, in order to achieve that, we're just going to ban it for everybody. That might achieve the goal you're after, but you're infringing on the rights of everybody else in achieving that goal, as noble as it might be. Just because a goal is noble, just because achieving that goal would maybe reduce crime or achieve something that's positive for society, you're adding a bunch of negatives that actually infringe on people's rights, and the Second Amendment is there to prevent you from doing just that. Now, in addition to the governor of California and the attorney general, anti-gun advocates have come out fiercely against this decision and this judge, who they already are not happy with due to the magazine decision that he had earlier. But take a look at the president of the Brady Center to Prevent Gun Violence and what she had to say.
I'm incredulous, and I think this judge doesn't deserve to be on the bench. It's a gross mischaracterization of facts from what I've read, and I find it deeply, honestly humiliating. It makes me ashamed to be an American.
And Chris Brown called the judge a shill for the gun industry who just wants to sell guns to Americans. She expressed deep frustration with what she calls disingenuous arguments to put more dangerous weapons in people's hands.
Wow, so she's ashamed to be an American. The judge should be removed from the bench. That he's a shill for the gun industry who just wants to sell more guns. I don't know why the reporter said that's what she said at the end when they had video and they could have just said that themselves. I would have liked to see that. That's kind of hilarious. But they are not handling this well. And it's weird because the California assault weapons ban doesn't even really ban the types of weapons these activists want to ban. It bans features. You can take two identical guns when it comes to their core functional components and just switch out little plastic parts known as the evil features, like a pistol grip or a flash hider or a forward grip or a telescoping buttstock. Any of these types of features are a thing that would take a gun that would otherwise be legal and then make it illegal into an assault weapon under California law. So these laws don't actually really save lives. They don't result in mass shootings being eliminated from California. In fact, the most recent mass shooting in the United States, the major one at least, was in San Jose, California with 9 fatalities, which you can see here on this Mother Jones database of U.S. mass shootings up till the present day. And you can see the most recent one, San Jose, with 9 fatalities. And in that case, it was a handgun that was used. Let's also not forget the mass shooting in San Bernardino, California, where this criminal couple used AR-15 rifles, which are supposed to be banned in California under the assault weapons ban. They used these rifles to kill 14 people and injured 21 others. Anyways, guys, I wanted to give you this update. What are your thoughts? Let me know in the comments down below. Don't forget to like, comment, and subscribe. Social media links are in the description box below, as well as merch. Support us at nuancebro.com/join, and I'll see you next time, bro.